Good afternoon, Your Honor. In regards to the defense's motion to suppress any evidence I gathered during my duties as the fire investigator of the structure fire located at 614 May Street and the subsequent charges of arson as a violation of the homeowner's constitutional rights and protection under the Fourth Amendment. The question raised by the defense is whether the evidence should be admissible in a court of law due to the nature of how the evidence was collected. I would counter that there was no willful or negligent malice or disregard for the defendant's civil liberties and submit the three following evidentiary statements as testimony that all evidence was gathered, not as an unreasonable search and seizure, but rather as an exigent circumstance, and as such should be allowed. First, I would submit as evidence the following three graphs logged as figures 1, 2, and 3 as presented by the Federal Bureau of Investigation into the statistics of arson nationally in 2018. This evidence is selected as the serious nature, monetary impacts, and the prosecutionary difficulties regarding fraudulent arson cases. Graph number 1 depicts the national statistics and the average cost of arson at single-family occupancies in the United States. The average cost of $27,750 for each fraudulent arson case indicates the significant impact and monetary costs of these cases. In 2018, the total number of single-family occupancies investigated as arson were 7,277 nationally. Of those 7,277 cases, 24.6% were successfully prosecuted, or 1,790 cases were closed due to an arrest or other exceptional means. Additionally, I would submit State of Minnesota versus Ackerman, a case in which an appellate court upheld a guilty conviction against Ackerman In Figure 1, you will see of the roughly 35,000 investigated arson offenses, 7,277 are investigated as residential single-family homes. In Figure 2, you will also see that the average cost of damages during these arson cases is estimated at $27,750. Lastly, in Figure 3, you will see that of the 7,277 cases of arson reported in single-family occupancies, a total of 1,790, or 24.6%, are prosecuted successfully with either arrests or with some other exceptional means. These statistics depict an ongoing struggle with fire investigators and their ability to prosecute arson cases, and the significant millions of dollars impact that these crimes present nationally. Additionally, I would submit to you State of Minnesota versus Ackerson Appeals Court case in which an appellate court upheld the guilty conviction of Ackerson against his defense attorney's motion that, although he pleaded guilty, his actions and the minimal damage caused by the fire was much less serious than other first-degree arson convictions. It should be noted that during this case, Ackerson denied any guilt until he was compelled with the significant evidence gathered during the fire investigation, much of which was done the same way I gathered my evidence at 614 May Street. This case is proof at the extent of which any defendant will go to deny charges of arson and the serious nature of what these cases bring. It is also proof that regardless of damage and subsequent cost, all arson investigations should be considered callous, serious, regardless of the circumstance. Lastly, and perhaps most compellingly, I would submit to you the Idaho Court of Appeals case Smith v. State, docket number 3135, the search of an arson site without a warrant. In this case, the unattended smoldering couch in the driveway led to Smith being charged with the manufacturing of a controlled substance. Due to the nature of the unattended couch fire and the subsequent fire investigation, Smith's unattended apartment was searched prior to his consent. During the search, police officers noted a small marijuana plant and other drug paraphernalia. Smith was contacted to return home, where the police officer advised they had enough for a warrant and urged him to sign consent for further search. Smith agreed and subsequently ended up being charged with a crime. Prior to trial, Smith's attorney alleged that his client's agreement to search was coerced and that his rights were violated under the Constitution and the Fourth Amendment. A lower court agreed and suppressed the evidence. State of Idaho appealed to the state's appeals court, in which the appeals court overturned the lower court's ruling, stating that due to the exigent circumstances that the subsequent investigation of the origin of the fire resulted in Smith's conviction. I would conclude that the exigent circumstances regarding an additionally reported structure fire with children trapped resulted in a brief period of the unattended building at 614 May Street. Due to such exigent circumstances, we can conclude that the investigation was done properly, and as such, the evidence should be allowed. Thank you.